Hi everyone, it's Carol Williams with Williams Immigration, back for another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. So y'all know I like to dive right on in. So the first thing I want to talk to you about this beautiful Monday morning is employment authorization for spouses. There are some non-immigrant visa categories where the spouses automatically get work authorization. They don't have to apply for an EAD card. There's no extra application. Just as soon as they're stamped in correctly by CBP, they are given work authorization. And they can show their I-94 card, which they can pull offline, to a potential employer, and that shows that they are authorized to work. So those categories are spouses of E1s and E2s. Those are our treaty investors and our treaty traders, as well as E3s. Those are our specialty occupation individuals that are coming specifically from Australia, as well as our L1s. So our spouses of L1s are intercompany transfers. They are also automatically given work authorization just because they are the spouse and they are stamped in the dependent status. So I wanted to remind everybody of that. I've gotten a couple questions about that over the past about a week or so. So I wanted to just remind people of that. So if you make sure that you pull your I-94 offline once you get in, assuming you're stamped in correctly from CBP when you're in the airport, you are, as a spouse, automatically authorized to work. Now, if you are a dependent child, but you're of work age, let's say you're 16, 17, 18, and you want to get a job, you are not given work authorization immediately. So just keep that in mind. I do get questions about, can my children, get a summer job like all their friends? So your children do not automatically get work authorization, only the spouses. The next topic that I want to talk about with y'all this morning are biometric fees. So we've been talking a little bit about biometric fees the past couple of weeks. So this week, I want to remind you all that as of October 1st, so a couple days, maybe about 2 weeks ago now, but as of October 1st, USCIS is exempting the biometric fee. So that $85 fee for the change of status form, the I-539, is no longer needed. So you do not need to pay that extra $85 fee as long as your application was postmarked October 1 and later. So if you're filing something today, you don't need the biometric fee. Now, if you filed prior to October 1, you should have included your biometric fee. And if you are called for biometrics, you definitely want to go to your biometrics appointment. That is low-hanging fruit for the Immigration Service to deny an application if they see that biometric notice was sent out and that biometrics were not taken. So regardless if you pay the fee or not, if USCIS sends you a biometric notice, make sure that you are going to your biometric appointment. And your biometrics, just as a reminder, is when they take your fingerprints and your photograph. And that's what they use to run your background checks, or their background checks, rather. The next topic is the ability to change your address with CIS. So when you move, you must change your address with USCIS. Some people have problems doing it online. Some people have problems sending in the form. It's been sort of all over the map for quite some time now. So USCIS has heard us, and they have launched what they're calling an enterprise change of address system. So it is completely self-service. It is completely online. Couple things with it though. You must have a My USCIS online account in order to use this. So if you don't have a My USCIS account, you still have to use now what's considered the old ways, right? You can, with your My USCIS account, you can update your mailing as well as your physical address with USCIS through your My USCIS account. You can change your address for pending applications, meaning the service center already has them, or USCIS already has your application. You can also change them for one application. It doesn't have to be, you can just change them for one application. So keep that in mind. Now, the sort of downfall of the system at this moment, because it's new, is that it's only available in English. So if English is not your primary language, if English is not a language that you feel 100% comfortable in speaking with, if you don't have someone to help translate for you, you can still change your address using the older methods, okay? So if you don't speak English, you're not out in the cold, it's not that you don't have to change your address, it's just that you can't log into your My USCIS account and change it through there, okay? So just keep that in mind. So it's a new system, it may be a little glitchy, folks. New technology is always a little bit glitchy. But again, if you have a My USCIS account, you have an application that's pending, you can use this new system. The other thing about this new system is that you can also use it if you don't have a currently pending application. So let's say, your application is approved, but you still need to tell CIS that you've moved, you can do that now. And if you've ever tried to send the Immigration Service something where they haven't specifically requested it, then you know how difficult it is sometimes to get that in the file. But now it's being done through the My USCIS account. So that's our update on change of address. A little bit different of an update than what I normally give, but still immigration related. So Department of Justice and the Consumer Financial Protection Bureau, I'm going to say that again, the Department of Justice and the Consumer Financial Protection Bureau have recently issued a joint statement. And that joint statement essentially says that financial institutions, so banks, folks that are lending, credit, lending funds to people, when you fill out your credit application, you cannot discriminate based on someone's national origin, their race, or anything related to their immigration status. So it's a little bit of a different update than I normally give. Usually my updates are, sort of hardcore immigration only, what's going on with the applications, what's going on with the policy. But this one I thought I would let you guys know about in case, this is something that you have been dealing with or something, that you're not quite sure of. But it was a joint statement that was released by the DOJ and the Consumer Financial Protection Bureau. So you cannot discriminate on someone based upon their immigration status. So just keep that in mind. And if anybody needs a copy of that joint statement, you can ping me. I'm more than happy to send that out to you. Next topic of discussion is the diversity visa. So the diversity visa is open, y'all. It is open. So it opened on October 4th and it closes on November 7th. And so when I say it's open, I mean that you can register to be in the lottery. Diversity visa lottery is just that. It is a lottery. And not all countries are eligible for the diversity visa lottery. So you want to make sure that your country is eligible and you want to make sure that you meet the eligibility requirements. But the diversity visa lottery for DV 2025 is open and it closes November 7th. So if you are going to enter into that lottery, I always say do so sooner rather than later. Do not wait until November 6th or November 7th in the morning. You want to make sure that you don't have any technical issues. And if you do, you've got a couple of days to sort them out, okay? Next thing we're going to talk about this morning is USCIS has issued approximately $22 million in fiscal year 2023 for citizenship and integration grants. This is something that the Immigration Service does. They essentially award grants to organizations that are helping prepare lawful permanent residents to become citizens. It could be helping them fill out the applications. It could be supporting them with English classes. Could be supporting them with the civics portion of the test. But it is organizations that are supporting lawful permanent residents or green card holders. We use those terms interchangeably. In their desire to become U.S. citizens and to naturalize. So the breakdown of that $22 million is those grants went to 65 organizations and those organizations were spread out amongst 29 states. So the reason I mention this today is that I often get questions as I'm out and about, people find out what I do. I often get questions for individuals that need help either with studying for the application, they're not quite sure, or they feel very uncomfortable doing an interview with a stranger in English. And so some of these organizations that have received these grants help with just that. So I try to help people find organizations, if I'm able, that will help them, study for the exam or get prepared for the exam. But USCIS does give out grants, and they have recently awarded over $22 million in grants. So 29 states, 65 organizations. Chances are they might be an organization near you that can help you if this is of interest to you. And the last thing I want to talk about this morning is the National Interest Waiver. So if you've been at all listening to me or following me on social media, you know that National Interest Waiver is a second preference green card application. It is a way to get a green card through employment, through your career path. It is, because it's second preference, typically a master's degree or higher is required for the endeavor. If you don't have a master's degree, then you need to show that you have exceptional ability in your field. And you also must show that your proposed endeavor has substantial merit and national importance to the United States, and that you are well positioned to advance your particular endeavor or your career path. And third, on balance, it is in the best interest of the United States to waive the normal EB-2 requirements, which include having a job offer and going through the labor certification application process through Department of Labor, which requires a company to advertise for the position and actively look for current U.S. citizens who can fill that role. So the tip I have today is based on the question that I received last week. So, and that question was, can an employer sponsor their employee for a green card using the National Interest Waiver category? And the answer is absolutely, you can. Absolutely. Absolutely. A lot of times I talk about the National Interest Waiver as a way for an employee or someone who has this amazing idea that they want to advance, but they may not have an employer. We talk about it in that sense that they can self-sponsor without an employer. But as an employer, if the National Interest Waiver is, the best move forward or a strategy that you can employ, absolutely. Absolutely. As an employer, you can sponsor an employee for their green card using the National Interest Waiver. So if you have any questions on the National Interest Waiver or anything else that I've spoken about today, or your immigration case, or you're confused about how to hire that perfect candidate that you have found who happens to not be a U.S. citizen, you are welcome to reach out to my office. We can get you scheduled for a consultation and see how we can help you. I'm Carol Williams. This is Beyond the Soundbite, another Monday morning edition of all things immigration. I hope you'll have a beautiful rest of your Monday and a great rest